It is commonly said that police is your friend, but the manifestation of what we see here in Nigeria, does it depict so? It depends on your perception of what the police is as regards how you've been interfaced with the police. So many notions arise, but basically we look at the law enforcement agents and what they should be, how friendly they should be in the course and discharge of their duties. Are they really, really harsh on the citizenry? Or is it the otherwise? How do we promote, viable objectives that will help bring a close relationship between the citizenry and the police in order to have a healthy society? Is the crux of today's discussion on law and you. My name is Philip Omo Gyukmo. As usual, we always have an opportunity to discuss with legal practitioners so that we can help to clear gray areas in this sector of industry where we look at the need for us to bridge the gap between the citizenry and, of course, the government agencies. And discussing this vital topic with me is a legal practitioner par excellence, and he is Greg Iyayi. Thanks for joining me, Greg.
Good day, Philip, and good day, all viewers.
All right, so let's look at what police brutality is. Basically, there's a general perception, yes. And we can't forget about what transpired in the NSAS, protest in the year 2020. Some see police as being brutal. So what is your perception, or how do you attempt a simple definition on what police brutality is?
My own perception of police brutality is this: the excessive use of force in enforcing the law. Because if you are enforcing the law, you are also guided by the law. And often, many people forget that even the suspect has rights that should not be breached. For instance, if a police officer wants to arrest someone, except the person you want to arrest is violent, you don't use handcuff. The Police Act does not require you to use handcuffs on the person unless that particular person is violent and there's the likelihood of his attacking a policeman. So when you put handcuffs on the person who has not been violent, it is police brutality. Then you don't slap, you don't kick, and you don't give a punch on a person unless the person proves violence. And then let me go to one very important area. Even when a suspect is violent, there's what you call proportionate force. If a suspect slaps a policeman, you cannot fire a shot because that force is not proportionate. You can maybe slap in self-defense, only in self-defense. And the likelihood that the person, if you do not stop him, is going to come on you. But if he's coming on you with bare hands, you cannot face him with a gun. So proportionate force, even in arresting a person, a violent person, or quelling riots, must be taken into consideration. And anything that is not proportionate is brutality. Another form of brutality is trying to use torture to get information from a suspect. We used to hear in those days things like hanging, putting blocks on a person's waist.
Wow.
And so many things. The state CID in those days was notorious for these things. And they will tell you by the time we drill you, the use of torture to extract information is a form of police brutality. And the courts have taken note of this. That is what gave rise to trial within trial.
Okay.
Because even if a statement is tendered in court and is signed by by a defendant, and the defendant alleges that yes, I signed that statement, or I made that statement and signed it, but I did so under duress. I was tortured, and for fear of my life and grave harm, I had to do it. The court will set aside the normal trial and go into what you call trial within trial. That is to ascertain whether that confessional statement was actually extracted by force or it was voluntarily given.
That's quite exhaustive. Thank you for your articulation on that. Just to let you know, the numbers are writing on the screen at which you can always react to what the legal practitioner has said as regards this very, very sensitive topic. Send in your contributions or what you want us to discuss so that we can have it, panned out in our subsequent episode. And just to let you also know, this program is brought to you, Law and You, courtesy of Noah Attorneys, a firm of legal practitioners based in Benin City, Nigeria. And so you can activate your contributions by sending short messages via WhatsApp and, of course, SMS on the numbers writing on the screen. Now, let's look at the relevance of training, for instance, on our police officers.
Yes.
We usually see this brutality, and you made mention of the fact that in those days, do you have an impression that the police force has improved in Nigeria in terms of bringing remedies that will help reduce, such strain that comes from brutality? Or what do you see as relevance of training? Are they being trained, or is there an absence of it? And how do we go about it?
Well, I think you have mentioned a very critical point, the issue of training. I think before now, police were not actually given the kind of training that placed, the rights of the suspect or defendants, in focus.
Okay.
Because they just believed that once somebody is trained, and once somebody is suspected of or committing an offense, that anything could just be done to him.
Yeah.
But again, you cannot really blame the police. Look at the educational qualification of the policemen of those days. It was very, very low.
Okay.
So the inability to comprehend that a suspect has rights was actually there because of their low level of education. And then the way some of the units in the police force came into being. Let me give a little bit of background about how the police mobile force came into existence. The police mobile force is actually a police unit within the police family.
Okay.
Amadou Bello visited the Philippines when he was premier of northern Nigeria, and he saw the way Ferdinand Marcos, that dictator, was using the mobile police force to suppress riots and revolts and then dissidents. So he admired it. But when he was having a problem, particularly with the TV people in Benue State, who were very restive and who were very consistent in their opposition against, Hausa Fulani domination. So when he came back to Nigeria, he took, his party was in power at the federal level, NPC, the Northern People's Congress. He took the idea back to the Tafawa Balewa government.
Yeah.
That, there's a way we can deal with dissent. There's a way we can deal with these TV people, particularly in the middle belts. And then that was how the police mobile force came into existence. A unit within the police that comes into existence from that kind of background, you expect them to be crude. And they were very primitive in the handling of anybody that was seen as a suspect. So the way some of these police units came into power actually will tell you why they couldn't be refined. But we are happy that gradually things are changing. And then one of the areas where things are actually changing is the act when it comes to the administration of a Criminal Justice Act, which provides that if somebody is suspected of having committed a crime and he's making a statement, his attorney, his lawyer has to be there. And that if his lawyer is not there, or if he doesn't even have a lawyer, you call on the legal aid council to provide him a lawyer.
Okay, legal aid council of the state.
Yeah, legal aid council of the state. Okay. They are in every state, and they are a group of lawyers. It's funded by the government to help people who are indigent and cannot afford a lawyer to actually have a lawyer represent them. So they can call on any of the lawyers to stand by him and guide him. He cannot write the statement for him. He cannot dictate any statement for him. But he will at least guide him on how not to make statements that are likely to implicate him, in the course of the trial. And press on him that whatever you write can be used against you in any judicial proceeding. So this is an improvement. I've had experiences of it where some people were arrested, they will call, and the police will wait till I arrive. And till I arrive, the person will not be forced, compelled to make any statement. And when you get there, you guide your clients, and then they cannot make the statement. Unlike before, when they will even tell them what to write, or even write a statement and ask them to sign, under duress. So there are noticeable improvements. We are not there yet.
Okay, let's look at suspects, criminal suspects, for instance. Yes. Because if we say police brutality, it's like you said earlier, torture is also captured in it.
Yes.
Now, we've seen situations where, the police torture suspects. And criminal suspects, for instance, who may have to be given some brutality before they make confessions.
Yes.
Is it legal? Is it right to extract information from criminal suspects in duress?
You have already answered the question. You said in duress. You don't, even if it's not duress, and you kind of give the person money, promise him something, to extract the statement from him. You didn't beat him, you didn't torture him. You enticed him with one thing or the other. It is still not a statement that meets the threshold of, an involuntary statement. What I mean is this: supposing you tell somebody, I'm going to give you some money if you make this confession, and you actually perhaps bring the money, give to him, it doesn't meet the standard of a statement that was made voluntarily. So the issue of torture is out of it, because by the time you are, why do we say that juju, extracting statements from people that they are guilty when they are taken to juju shrines and so on? Because we are told that that kind of this thing is extracting statement from them under fear, under torture. You give them something to drink, and if they fall, then you say that the person is guilty.
So that's also wrong.
It's completely wrong. And that's why the law says that juju is not known to law. So anything you say, the person fell by juju, we found out by juju, by divination, that the person was the one who took the money who stole the money, who stole the goods, is not accepted. It's not a credible evidence. So what we are saying is this: suspects should be allowed to make their statement voluntarily.
Okay, let's paint a different scenario, because it's usually said in law that not until someone is proven guilty, he is presumed to be innocent.
Yes.
Now, let's look at hardened criminal suspects, for instance, because we see situations where you've seen it, that this person committed a crime. Armed robbery suspect, for instance, the person is really guilty because you saw him. There is evidence, everything that has to do with revealing that he did this act. They are there, and then the police is trying to extract information from them. Hardened criminal suspects, they hardly speak until they are given some torture, as we are being made to understand.
Yes.
Now, how do you correlate this? What is your advice in terms of extracting information from these elements who may be difficult to get information from except they are being tortured?
The position of the law is that they should not be tortured, and that they should be made to know that you already know. Convince them that you are aware, and that if you get to court, you can prove that they did.
Provide the evidence.
You can provide the evidence. Even if a judge saw someone from the balcony of his house hitting somebody, and the person fell and died, and they brought that case to his courts, he's still going to ask the person, are you guilty or you are not guilty?
Oh, is that right?
And if the person says, I'm not guilty, that's the principle of the Garden of Eden trial. God knew Adam had done it. He said, have you eaten of the forbidden fruit or not? It's a guiding principle in law, because the presumption of innocence is a constitutional provision.
Okay.
Safeguard, particularly in criminal trials, and it's always in favor of the accused. That you have the burden, you accusing him, you have the burden to prove beyond reasonable doubt that he is actually guilty of the offense you are alleging. Put your cards on the table according to law, not by torture, and then let the court decide. And if it is found out, supposing you torture a criminal and he is able to prove in court that that statement you extracted from him, you inflicted wounds on him, and that you beat him and he was in a bad state of health, and you wrote the statement and brought for him to sign, and you threatened him, if he doesn't sign, you will shoot him. I mean, the statement will not be accepted. It will be inadmissible, in the courts. So this is why we always encourage the police. There are modern methods. You talked about training, where some of these detectives can be trained in ascertaining certain facts that will be irrefutable when it gets to court. And many people are lazy, and we are lazy as if people. We do not want to go on that lane because it is cumbersome. But that is what the people in the civilized crime have done, that makes that legal system very, very refined and enviable, that we all look at it and we want to be there. But the road to it is very cumbersome, but it is safer. It is better because, you see, Philip, the position of the law is this, that 1,000 guilty people should rather go free than for one innocent person to go to jail.
Wow.
Even for 1 hour.
Wow.
That's the position of the law.
Well, that's quite interesting, and that shows that anything that has to do with incriminating any suspect is done based on evidence. Produce your evidence in the law court, and that will establish it, why the suspect is being cross-examined, and not unnecessarily using the rule of force as a policeman. Well, just to let you know, again, this program is brought to you courtesy of Noah Attorneys, and Noah Attorneys is a firm of legal practitioners based in Benin City, Nigeria. The numbers are writing on the screen, and it's for you to react. Send your questions, send your statements, reactions to it via SMS and, of course, WhatsApp, and we get it, and that can help us to pan out a new episode on that. Before we round off on this, let's look at issues as regards remedies. And basically, if a citizen is being brutalized by the police, who should be the first person, or where should be the first place he or she should go? Is it the police station, or the church, or the media, or the court?
Yes. It's still the police. First of all, completely.
It's still the police?
Yes.
But they say in your in the law jargon, memo judice in causa. You can't be a judge in your case.
Yes, you have to inform the higher authorities. That is why if the police stations even have jurisdiction, if you were your case was unfairly treated in a division, you can write a petition to the area command to review that case and treat that case more fairly. If at the area command your case was not fairly treated, you can go to the police command headquarters.
Okay.
The police headquarters in the states. And if the state commissioner of police does not treat your case fairly, you can go to the AIG. If the AIG does not even treat your case fairly, you have the right to petition him.
But you'll be doing this with the help of a lawyer?
Of course.
Okay.
Of course. And you can even on your own right. You can even on your own right. But so that you can put it in proper legal perspective.
Exactly.
You need a lawyer.
Yes.
Yeah, and it's always advisable that you get a lawyer. You can petition the IG. And the IG will send a team and they will look into the case.
Okay.
So because they know that there's possibility of any of the formations, not treating your case fairly, you are still given the opportunity to petition to a higher body. And then your case will be looked at again. Just like in the judiciary, you can go from magistrate to high court, appeal, and then from high court to court of appeal, from court of appeal to possibly the Supreme Court. Okay. There's always room for that review. It is provided for in case there was any error, miscarriage of justice, so that a redress can be found. And then you can also go to court and take out a civil action.
Okay. Thank you so much, Greg Iyayi, legal practitioner par excellence. Big thanks for your articulation, and I wish you a beautiful day ahead of you. You should always react, and the numbers on the screen are there. And Noah Artonis will be sending legal practitioners to participate on the platform of the program Law and You in order to bring, settlement to cases of dispute in a society, most especially as regards police brutality and how to profile solutions and remedies in Nigeria. I am Philip Omo Gyukpo. We do this same time next week. It's bye for now.